When Governor Gavin Newsom signed California Senate Bill 553 into law, it ushered in a new era of workplace violence prevention in California workplaces. This new bill requires employers to follow specific guidelines to be compliant with the law. There are four main components of the law: the Workplace Violence Prevention Plan, employee training, the Violent Incidents Log, and temporary restraining orders. SB 553 applies to all employers and employees in the state, with a few exceptions. Healthcare employees who are already covered by OSHA's Prevention in Healthcare standard. Employees who choose to work from home in a location that is outside of their employer's control. Employees who work in locations that are not open to the public, where fewer than 10 employees work at any given time. Employees who work for the Department of Corrections and Rehabilitation, and employees who work for law enforcement agencies. The most expansive change to the law is the Workplace Violence Prevention Plan. Employers are required to develop a written plan that is easily accessible to all employees at all times in all work areas. The plan must include the names and/or job titles of the employees in charge of implementing and maintaining the plan. Their roles within the plan must be clearly identified. How workplace violence hazards will be evaluated and identified. Employers must make periodic inspections to identify hazards and evaluate employee reports and concerns. These inspections must occur when the plan is established, after each incident, and whenever employers are made aware of a new or previously unrecognized hazard. Workplace violence hazards specific to each of the employer's workplaces. How employers will implement the plan among employees in the same facility or department. How workplace violence matters will be communicated to the workforce. How training will be developed and implemented. Procedures to seek assistance from law enforcement or emergency services. These procedures must include a written statement that employers may not prevent employees from calling for emergency services or law enforcement, and that punishment or retaliation for doing so is strictly prohibited. The procedure for employees to report incidents, threats, or workplace violence concerns to their employer. This procedure must include a statement that employees may not be retaliated against for reporting concerns. How the organization will respond to and investigate violent incidents, threats, or concerns, and how the results of these investigations will be communicated. Procedures to respond to actual or potential emergencies, including how employees will be alerted to the presence, location, and nature of the emergency. Evacuation and sheltering procedures specific to each workplace. How to contact staff or security personnel. Procedures to correct hazards quickly and effectively. Procedures to ensure that other employers, such as staffing agencies and consultants, adhere to the plan. Procedures to ensure employees comply with the plan. How the organization will review the plan's effectiveness annually when deficiencies are identified and after workplace violence incidents. Additionally, employees must be actively involved in the development and implementation of the plan. This involvement must include identifying, evaluating, and correcting workplace violence hazards, designing and implementing training, reporting and investigating workplace violence incidents. Workplace violence prevention plans must be reviewed annually when an issue is identified and after a workplace violence incident. Records of workplace violence hazard identification, evaluation, and correction shall be created and maintained for a minimum of 5 years. Employers must train their employees on their specific workplace violence prevention plan. This training must include how to identify workplace violence hazards, understand the potential threats associated with their roles, report workplace violence hazards and incidents, seek assistance from law enforcement, emergency services, or their employer to prevent or respond to incidents, and receive information about the violent incident log and how to obtain a copy. Additional training is required when a new workplace violence threat or hazard is identified, or when there are changes to the plan. Training records must be maintained for at least 1 year and include training dates, the contents of the training sessions, names and qualifications of the persons conducting the training, and the names and job titles of all persons who attend the training. In California, employers are required to record every workplace violence incident in a violent incident log. Information recorded in the log should be based on employees who witnessed the workplace violence, employees who experienced the violence, and findings of the investigation. Personal information that could reveal a person's identity must be omitted from the violent incident log. This information includes names, addresses, emails, telephone numbers, and social security numbers. No personal medical information should be included in the log. The log must include the date, time, and location of the incident, a detailed description of the incident, a classification of who committed the violence, such as a client, customer, relative, or friend of an employee, stranger, co-worker, supervisor, partner, or spouse, the circumstances of the incident. For instance, employees were engaged in their usual job duties, working in poorly lit areas, rushed to complete a task, isolated or alone, working in an unfamiliar or new location, and any other pertinent details. Where the incident occurred, for instance, the workplace, parking lot, or outside the workplace. The type of violence that was committed, for example, physical attack with a weapon, physical attack without a weapon, threat of physical force, sexual assault or threat of sexual assault, animal attack, whether law enforcement or company security was contacted, the actions taken to protect employees from the threat, the consequences of the incident. Violent incident logs with personal identifying information omitted must be retained for 5 years. Employees are entitled to view and copy the log. However, employers have 15 calendar days to respond to a request. Under the new law, both employers and collective bargaining representatives can petition for temporary restraining orders for employees. Temporary restraining orders may be sought for employees who have endured harassment, unlawful violence, or credible threats of unlawful violence in the workplace. Additionally, the law allows for employee names to be withheld from temporary restraining orders. This anonymity will encourage employees who fear reprisals to seek help. The bill does not mandate temporary restraining orders. However, these orders give employers an extra tool to protect their employees. Although there are several detailed steps employers must take to comply with SB 553, the benefits are immeasurable. A clearly defined plan will reduce violence in the workplace and save employees from mental and physical injury, and maybe even death. From a business perspective, employees who feel safe are more productive and efficient. By carefully following the plan, employers will not only reap the benefits of employee morale, but they will help achieve their most important duty: to keep employees safe.